Hello, everyone, and thank you for joining us this evening. There should be a globe icon near the hand feature of your screen. This will allow you to listen and participate in tonight's event in Spanish. Our interpreters this evening are Angela Thielen and Jose Luis Guzman. I do want to thank you both for your time and services this evening. And Jose, would you be able to translate that in the English version so folks know how to go to that globe? Okay, so this time, I'm going to just check my interpreter services. I appreciate everyone's patience. Okay. So I just wanted to confirm that Angela, you are able to provide the interpretation services as well as Jose. Okay. It does look like we have Angela and Jose on. So at this time, I'm going to officially be calling this meeting to order. So welcome to the Independent Redistricting Commission's November 18th special meeting. This is a teleconference meeting with IRC members, city staff, and members of the public participating remotely to ensure proper social distancing in this federal, state, and local emergency. I'd like to introduce staff and commissioners present. We have Commissioner Ariano, Gilmer, and Walter. Staff present include City Clerk Judy Herron, that's me, Assistant City Attorney Denise Pisano, and Administrative Assistant Sarah Sandoval. At this time, I'm going to ask that the commissioners remain on screen for the duration of the meeting, engaging your own webcams and microphones. For members of the public who wish to provide comment on any of tonight's agenda items, we'll ask that you engage that hand feature in the bottom of your screen. If you are calling in from a landline or a cell phone, you can press *9 after public comment is called on that item. Next on our agenda is going to be our first public hearing. And this public hearing is a formal proceeding held in order to receive testimony from all interested parties on a proposed issue or action. Our first public hearing is Z1, the selection of 4 independent redistricting commissioners and 2 alternates. A little background on this item. On November 4, the city clerk selected the first 3 commissioners at random. Again, that's Commissioner Ariano, Gilmer, and Walter. The week of November 8th, the commissioner interviewed all of the applicants. I did want to note that we had one withdrawn application, which left 11 qualified applicants for interviews. And the next step for our 3 commissioners is to select 4 commissioners and then 2 alternates. Are there any clarifying questions from the commission before we open the public hearing to public comment? Seeing none, at this time, we're going to open the public hearing for public comment. So for any member of the public who wishes to speak on item C1, selection of 4 independent redistricting commissioners and 2 alternates, please engage that hand feature in the bottom of your screen. If you're calling in from a landline or a cell phone, you can press *9 now. This will be the final call for public comment on item C1. And seeing none, I'm going to officially close the C1 public hearing. And I will open this up for our commission discussion as well as appointment.
Thank you, City Clerk Herron. Before we nominate our commissioners, I did just want to offer some brief remarks on our selection process. Commissioners Gilman, Walter, and I, along with Judy Herron and Sarah Sandoval from the City Clerk's office, met last Friday afternoon via Zoom to debrief and discuss each applicant, their qualifications, and our respective impressions from the interviews. I will say that we had the luxury of a very deep and very well qualified pool. And in selecting the commissioners, however, we did want to, of course, follow the direction of the City Council as stated in Resolution 6659, and tried to assemble a group who, along with ourselves, represents a broad and accurate cross-section of our community, taking into account the applicants' council districts, professional backgrounds, and past participation in the community, both formal and informal. And for the individuals who are not selected to serve as commissioners, or who we did not select for nomination rather, we did place everyone else on a list to serve as an alternate and then selected 2 alternates at random. Again, the selection process was very difficult. And so on behalf of Commissioners Gilman and Walter, we do thank you for taking the time to participate in the interview process. We, of course, welcome your continued participation in the redistricting process, and we would encourage you all to volunteer for another city board or commission as your time allows. And with that, I would make my first nomination, and I nominate Susan Earhart.
And I second that nomination.
Do we have any other nominations for the commissioner?
Did you want to go through each one individually, or do you want to do them all in one vote?
I think we can take all of the nominations now, and then we'll vote individually based on the order of the nomination received.
Oh, okay, very good.
Okay. I nominate Susanna Hill.
I nominate Nabil Saad.
Oh, was there a second for Commissioner Walter's nomination?
Sorry, I second Commissioner Walters' nomination.
Thank you. And then a second for Nabil.
I second that nomination.
Thank you.
I nominate Shonda Ballas.
I second that nomination.
Any further nominations for our commissioner spots? Seeing none, I will do a roll call vote for our first nominee of Susan Earhart. Commissioner Ariano?
Yes.
Commissioner Gilmer?
Yes.
Commissioner Walter.
Yes.
And I would like to congratulate our fourth commissioner, Susan Earhart. And Susan, at this time, I'm going to request you to be promoted to panelist, and you can join the commission on our virtual dais. And our second nominee was Susanna, was it Susanna Hill? Thank you. So by roll call vote, Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Walter.
Yes.
Thank you. And a congratulations to Susanna Hill. I'm also going to be promoting you so you can join us on our virtual dais. Our next nominee was Nabil Saab. By roll call vote, Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Walter.
Yes.
Another congratulations to our next commissioner, Saad. And Nabil, I'm going to be promoting you to join us on our virtual dais. And then our final nominee, Shonda Ballas. By roll call vote, Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
and Commissioner Walter.
Yes.
Another congratulations to Shonda. Shonda, I'm going to be promoting you to panelist to join us on our virtual dais. And so to our four newly appointed commissioners, I'll ask that you engage your webcams for the duration of the meeting. And again, just congratulations on your appointment. We will be moving on to our alternates. And I'm going to be removing those that were just appointed. Okay, so I'd like to open the floor to our three commissioners for nominations for our two alternates, please.
I would like to nominate Brian Kissel.
Second.
Thank you.
I would also like to nominate Marion McCourt. Hopefully I pronounced that correctly.
Second.
Thank you. Any further nominations? Seeing none, by roll call vote, Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Walter.
Yes.
Thank you. And a congratulations to Brian Kissel as one of our alternates. Brian, I will be promoting you to panelist to join us on our virtual dais. Okay, and then for Marion, by roll call vote, Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Walter.
Yes.
Thank you. And that does conclude our alternates, and a congratulations to Marion, who I will also be promoting to panelist. Just give some time to join. Give me a moment to update our panelists here. Okay. So that will conclude our first public hearing of C1. Our next public hearing item is C2. And before we move on to C2, I just did also want to express a huge thank you to all of the applicants who applied for the IRC. As stated by Commissioner Ariano, the caliber of the applicants was extremely high. And I also invite anyone who was not selected to be a commissioner or an alternate to please engage and participate in the redistricting process. It's going to be an exciting time in Menlo Park, and the more the merrier. So again, I truly appreciate you applying, and again, I hope to see you around the Zoom, so to speak. For those of you who were selected, I've promoted you all to panelists. And again, engage your webcams for the duration of this meeting. So this is going to be our last public hearing of the evening. And I'm going to ask that all of the commissioners and alternates raise their right hands. And you can repeat after me. You're going to be taking your oath. And just so you know, I will be sending this out via DocuSign for actual signature, but to officially have you start serving, I'm going to ask that again, you repeat after me. Thank you. I state your name.
I,
Mary Marquardt,
Do solemnly affirm
Do
solemnly
affirm
that I will support and defend
that I will
that I will
support and defend
the Constitution of the United States
the Constitution of the
Constitution of
United
the United
States
States
and the Constitution of the State of California
and the Constitution
and the Constitution of the
of
State
the
of
State of
California
California
against all enemies,
against all
against
enemies,
all enemies,
foreign and domestic,
foreign
foreign
and
foreign
and
and domestic,
domestic,
that I will bear true faith and allegiance
that I
that I
that I
will
will bear
bear
true
true
faith
faith
and
and
allegiance
allegiance
to the Constitution of the United States
to
to
the
the
to the
Constitution
Constitution
of
of the
the
United
United
States
States
and the Constitution of the State of California,
and
and
the
the
and the
Constitution
Constitution
of
of
the
the
State
State
of
of
California.
California,
that I take this obligation freely
that I take
I
this
take this obligation freely
without any mental reservation
without any
without any
mental
mental
reservation
reservation
or purpose of evasion,
or
or
for
purpose
purpose
of
of
purpose of
evasion,
evasion,
and that I will well and faithfully
and
and that
that
I
I
will
I will
well
well
and
and
faithfully
faithfully
discharge the duties
discharge the
discharge
duties
the
duties
upon which I'm about to enter.
upon which
on
I
which
am
I'm
about to
about to
enter.
enter.
Wonderful, congratulations. Thank you so much. Okay, so we are now going to move on to our first regular business item, which includes the action for all 7 of our commissioners. And what this is the selection of the Independent Redistricting Commission Chair and Vice Chair. An introduction of this item is the Chair of the IRC shall preside at all meetings, and the Vice Chair shall assume the duties of the Chair when the Chair is absent. The role of the IRC Chair, according to Robert's Rules of Order, is to open the session at the time at which the Commission is to meet and calling all members to order, to announce the business before the Commission in the order in which it is to be acted upon, to recognize members entitled to the floor, to state and put to vote all questions which are regularly moved or necessarily arise in the course of the proceedings, and to announce the results of the vote. It is also to assist in the expediting of business, recognizing the rights of the members and the public. And with that, is there any clarifying questions from the Commission before I open it to public comment? Seeing none. If any member of the public wishes to speak on item D1, selection of the Independent Redistricting Commission Chair and Vice Chair, please engage that hand feature in the bottom of your screen. If you're calling in from a landline or a cell phone, you may press *9 now. This will be the final call for public comment on item D1. And seeing none, I will be closing public comment. And give me one moment to bring up our chair and vice chair slide. Just wanting to update. Give me one more moment. Okay. So now we should be seeing our 7 commissioners here. Okay, and so at this time, I'm going to open up the nominations to the entire commission for the 1 chair position for the IRC.
I will start by nominating Ariana Cayo.
Do we have a second for Commissioner Ariano?
I will second that.
Confirming that was Commissioner Gilmer.
It was.
Thank you. Do we have any other nominations for chair? Seeing none, I will be doing a roll call vote. Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Walter,
Yes.
Commissioner Balls,
Yes.
Commissioner Earhart. Oh, I'm sorry, Commissioner Earhart, I didn't catch that. Getting a little bit of feedback from your end. It's almost like a robotic voice. Okay, thank you. I can take a thumbs up for now. Commissioner Hill,
Yes.
Commissioner Saad,
Yes.
and by unanimous vote, Commissioner Ariano, you are now our chair. Thank you. So our next job is going to be selecting a vice chair. And it will be the same process as before. Except the removal of Commissioner Ariano. Okay, So I'd like to open the floor for nominees for vice chair.
I nominate Commissioner Walter.
Do we have a second for Commissioner Walter?
Second.
Thank you. Do you have any further nominations?
Nominate Brian Gilmer.
Thank you. Do we have a second for Commissioner Gilmer?
Second.
And that was Commissioner Hill. Thank you. Any further nominations? Seeing none, we will start with Commissioner Walter by roll call vote. Commissioner Ariano,
Yes.
Commissioner Gilmer,
No.
Commissioner Walter,
No.
Commissioner Bales,
Sorry, I'm just going to try to settle it. Ballas.
Alice. Thank you so much. I
Fine.
apologize for that. I've
It's okay.
murdered it a couple of times.
It's moving around. So,
Alice.
sorry, who are we voting for? Gilmer?
This is for vice chair for Commissioner Walter.
Walter, okay, no.
Thank you. Commissioner Earhart. Thank you. Commissioner Hill.
No.
Thank you. Commissioner Saad.
Yes.
Yeah. So with a non-majority vote, we will move on to voting for Commissioner Gilmer as vice chair. Commissioner Ariano,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Walter,
Yes.
Commissioner Ballas.
Yes?
Thank you. Commissioner Earhart. Thank you. And for Commissioner Earhart, we're still getting quite a bit of background noise. Not sure if you're able to maybe change your audio into a call in. But yeah, there's quite a bit of background. Thank you. Commissioner Hill for Commissioner Gilmer as vice chair.
Yes.
Thank you. And Commissioner Saad.
Yes.
Thank you. And by unanimous vote, Commissioner Gilmer will be our vice chair. So congratulations.
Thank you.
And so just to kind of help with some of the feedback that we're getting, I'll ask everyone to mute unless you have a question or a response, or if we're doing a vote. Thank you. And so our next order of business is going to be item D3. So item D3 is adopt.
Karen?
resolution. Yes.
I'm thinking we're skipping D2, which is establishing the Independent Redistricting Commission's regular meeting schedule.
Perfect. Thank you, Assistant City Attorney. I appreciate that. Let me bring that item up. Okay. So our next item on the agenda is item D2, which is establishing the Independent Redistricting Commission's regular meeting schedule. The item that is before the commission tonight is to adopt a regular meeting schedule for the IRC. In accordance with state law and to increase transparency, it is recommended that the IRC adopt a regular meeting schedule which will be made available on the redistricting website. Staff is proposing a meeting schedule for the duration of the IRC charge. The proposed dates have been scheduled, taking into consideration City Council, Planning Commission, and the 7 city advisory body meeting schedules. Is there any clarifying questions from the commission before we go to public comment?
What's the frequency of the meeting?
It is in the staff report that is attached to the agenda. Let me see if I can pull up that for you and put it on the screen. Give me one moment. Here is the proposed schedule. It would typically be on Thursday evenings at 6 p.m. With the 2 public community meetings on Saturday, December 11th and Saturday, December 18th, both commencing at noon. Any other clarifying questions before we go to public comment?
Judy, if we have a conflict for one of the meetings, should we just go ahead and then inform you after the meeting about the conflict?
Yes, that's fine. And just so we all know, the IRC is a body of 7. So a quorum, which is required to have a meeting, would be 4. So if a commissioner isn't available on one meeting, that doesn't affect the ability to have a meeting. But if we have multiple commissioners absent from a meeting, that may make it difficult to actually hold the meeting. And we'll get a lot more information on that. It's related to the Brown Act from our city attorney's office later this evening.
So Judy, if we do have a conflict with a given meeting, would you be the person to let know? Or the
Yes,
chair? Oh, you, okay.
yes. Yes, I'll be the staff liaison for this commission. So I'm definitely your point of contact for any and everything. Any other questions before we go to public comment? None. So at this time, I would invite the public who wishes to speak on item D2, establishing the IRC's regular meeting schedule, to engage that hand feature in the bottom of your screen. If you're calling in from a landline or a cell phone, you can press *9 now. Final call for public comment on item D2. Let's see, no hands raised. I will return this item to the commission for an open discussion amongst the commissioners. And if there is no discussion, one of you could make a motion and then we could take a second.
I move to adopt the proposed IRC schedule as included in the agenda item prepared by the city clerk.
I'll second.
Thank you. So at this time, I have a motion on the floor by Commissioner Ariano and a second by Commissioner Ballas to adopt the IRC regular meeting schedule as proposed. Any further commission discussion or questions? Seeing none. By roll call vote, Commissioner Ballas,
Yes.
Commissioner Gilmer,
Yes.
Commissioner Earhart, thank you. Commissioner Walter, Commissioner Walter,
Yes.
thank you. Commissioner Hill,
Yes.
Commissioner Saad,
Yes.
and the motion passes unanimously. Thank you. So now I will be moving on to our next regular business item, which is adoption of resolution number 001-IRC, establishing the Independent Redistricting Commission's policies and procedures. This item, staff is recommending that the commission adopt this resolution, which establishes, again, the IRC's policies and procedures. These policies and procedures include meetings and officers, conduct and parliamentary procedures, a lack of quorum, meeting locations and dates, public appearances of commissioners, and the details of this were attached to the resolution in the staff report. Are there any clarifying questions from our commissioners before I open it up to public comment? Okay. Seeing no clarifying questions, I will go ahead and open this up for public comment. So for any member of the public who wishes to speak on item D3, adopting a resolution establishing the IRC's policies and procedures, please engage that hand feature in the bottom of your screen. If you're calling in from a landline or a cell phone, you may press *9 now. It looks like we do have one hand raised. It is a phone number ending in 6833. And if you could please state your name for the record before providing your comment.
Hi, Judy, that's me.
Oh.
Judy, it's Susan Earhart.
Beautiful. Okay, so I'm going to go ahead and keep your mic off mute, so you'll just control that from your phone.
Thank you.
Thank you. So final call for public comment on item D3. Seeing none, I will return this to the commission for any discussion or motion.
Yes, City Clerk Karen, I recognize that 4 of the newly appointed commissioners may not have had the opportunity to review the staff report and the resolution.
Mhm.
So, perhaps give them a couple of minutes to look it over if they have not had a chance to do so.
Thank you, Chair.
I read it.
Thank you, Commissioner Hill. Commissioner Earhart, I do see your hand raised. Did you want to make a comment?
I was going to make a motion to adopt the policies and procedures.
Thank you.
I second that motion.
Chair. I have a motion on the floor by Commissioner Earhart, a second by Vice Chair Gilmer to adopt resolution number 0001-IRC, establishing the Independent Redistricting Commission's policies and procedures. By roll call vote, Commissioner Ballas,
Yes.
Commissioner Gilmer, or Vice Chair Gilmer,
Yes.
my apologies. Commissioner Earhart,
Yeah.
Commissioner Walter,
Yes.
Commissioner Hill,
Yes.
Commissioner Saad,
Yes.
Chair Ariano,
Yes.
and the motion passes unanimously. Thank you. Okay. And so our next item is going to be a presentation on Assembly Bill 1234. And I would like to introduce our Assistant City Attorney, Denise Bazzano, to make that presentation to the Commission.
Good evening, Commissioners. Denise Bazzano, Assistant City Attorney. We are honored this evening to join you to provide you with some ethics training under the statutory requirements, which are usually referred to as their bill number AB 1234. I am joined this evening by an associate in our firm, Tamar Burke. And if I can.
Hi, everyone.
See where she is on the screen. We will both be assisting you during your meetings and as you go through this redistricting process. So either Tamar or myself will join you for the public hearings that you have identified in your schedule. And so we are both going to be doing the presentation but Tamar will only be able to do the first part and then she'll be signing off. She has family commitments this evening, but she was kind enough to join us for a portion of the presentation. So I will now turn it over to Tamar, and with the clerk's authorization, I'll go ahead and share my screen.
And you should be able to override what I have right now.
Okay. Okay. All right. So are you all seeing the introductory slide?
Yes, thank you.
Great. So I'll just start off with a little bit of background about myself and the firm, and then I'll ask Tamar to take it over and give her a little bit of background on her experience and workload so that you know a little bit about us. So I am a partner with the firm Burke Williams Sorensen. We we specialize in a lot of areas of different law, but primarily public law. We serve over, I believe, 23 cities as city attorneys, and I provide assistance to 5 cities as assistant city attorney. You know, on our day-to-day workloads, we handle many questions that relate to ethics and transparency for public officials. And we answer a lot of questions about the Brown Act, the Political Reform Act, Section 1099, lots of questions that will hopefully, we will be able to provide you some insight tonight on the answers to those questions and give you a little bit of information to help you act in an ethical and transparent manner as a newly appointed commissioner. I will say that this training is required to be 2 hours long, and it can be overwhelming. I would just recommend that you listen and be open to what we're presenting to you, but don't try to absorb it all. It's just too much to take in on one night. These are complex legal provisions that we're talking about this evening, statutes and laws. And so I would just say, try to listen and absorb at a very high level. So with that, I'll hand it over to Tamar.
Hi, everyone. I'm Tamar, and as Denise mentioned, I'm an associate with Burke Williams and Sorensen. I work out of the San Francisco office, although we're all from home right now, so sort of works from just my living room. Again, as Denise mentioned, in my sort of day-to-day practice, I do sort of about 50-50 litigation side work and city attorney sort of advisory work. And in both of those contexts, I handle a lot of Public Records Act issues, Brown Act issues, and conflict issues, all of which we're going to go through tonight. And again, these issues are super complex, very fact dependent. And so I think the main goal of this training is really just to sort of introduce you folks to the issues that you might see in your public service, just enough so that you know when to come to us to ask more specific questions. There's no such thing as a dumb question, and we love to answer them. So anytime you think that you might have something that you're not so sure about, just feel free to shoot me or Denise an email, and we can help you through that. Okay, so I think with that we can dive into this training. Denise, would you mind going over to the perfect? So this statute, which requires all public officials to have this ethics training, was adopted after a whole bunch of officials in the city of Bell were found guilty of just a slew of ethical violations, embezzlement. I don't remember all the other ones, but it was pretty intense. And the legislature thought that it was smart to have all public officials sort of get this primer in all of California's ethics laws so that this doesn't happen again. Go on to the next one. The FPPC, the Fair Political Practices Commission, is the state body that enforces all of these rules, and they do prosecute a bunch of these conflicts and ethical cases every year. I think last year they prosecuted about 240 cases, with the majority of them in Southern California, but it is a real issue that does get some attention at the state level. So it's important that we go through these and you folks avoid being one of those 240 cases that the FPPC prosecutes. Move on. I sort of alluded to this earlier, but the sooner you bring your questions to us, the better, just because it gives us more time to sort of really analyze the facts and the issues that you bring to us. But you should remember that the city attorney's office represents the city and not you personally. So it's important to sort of speak hypothetically. And reliance on advice from legal counsel is not a defense to your actions. Only a formal advice letter from the FPPC will protect you from violations of FPPC violations. So when you ask us for conflict advice, we'll look through the cases and we'll give you our best assessment, but ultimately the decision to act or not act will be up to you. And yes, I again mentioned this a little bit earlier, but because violations are personal to you, please do ask questions in the hypothetical. Don't confess horrible ethical violations to us. Will put us in an awkward position. So yes, that's, I think, our final warning before we dive in. All right, so the agenda for tonight, we're gonna have sort of 3 major topics or buckets of issues. The first is transparency laws. So we'll cover the Brown Act, which is the open meetings law. The second is the Public Records Act. And then the second big group of topics will be the personal financial interest and fair processes. That'll cover conflicts, a whole bunch of other things. And the last one is legal limitations on perks and advantages of office. Those are kind of, I think of them as kind of the miscellaneous ethics rules that you folks should be aware of. Okay, and again, I think I was getting ahead of myself earlier, but the goals of this are just to familiarize yourself with these ideas and these issues. We don't expect that you'll be a genius in all of this stuff by the end of these 2 hours, but it's important to at least be able to sort of spot potential issues to bring to our attention so that we can help you out and put your mind at ease. If it's not a problem, or if it is, we can work with you to get through it. And of course, it'll satisfy your AB 1234 requirement, which is very important. Okay, transparency laws. So the first section will be about the Brown Act. The Brown Act, the main goal is just to ensure that decisions relating to the public are made openly and in public. And so this means that everyone has to be permitted to attend any meeting. And the idea behind this is that we want the public to be aware of how governmental decisions are being made. And the only way to do that is to allow them to watch those decisions in person. We can move on to the next slide. Again, yeah, everyone has to be permitted to attend. All meetings have to be open and public, and that's why on Zoom we have to have, it has to be open to everyone, and we have to notice it so that folks know how to attend if they would like to. Next. Okay, so the basic rule of the Brown Act is that all meetings of legislative bodies are covered. Of course, because this is a legal theory, all of those terms have their own special definitions. So a legislative body includes standing committees or commissions, as well as advisory committees made up of less than but advisory committees that are made up of less than a quorum are not legislative bodies. So that's, I guess, one exception to the Brown Act meeting rule. A meeting, which is, I think, the more tricky part, is a gathering of a majority of the members of a legislative body at the same time and location to hear, discuss, deliberate, or take action upon any item which is within the subject matter jurisdiction of that body. So for you folks, a majority of the members is 4. So if 4 of you get together and talk about redistricting issues, that would be deemed a meeting under the Brown Act. Next. So there are 3 types of formal meetings which are covered by the Brown Act. And of course, they all require notice to the public, which will allow the public to attend those meetings. So the first is regular meetings, which requires 72 hours notice. And I think weekends are even okay. So if you post it on like a Thursday or Friday, that's counted. Special meetings, it's a little bit abbreviated, 24-hour notice is required. And emergency meetings, you can, as little as 1 hour's notice is enough, depending on the situation. So one of you mentioned earlier that you might be unable to attend one of the meetings. To the extent that you may want to teleconference in, under normal pre-COVID rules, there are pretty cumbersome teleconferencing requirements under the Brown Act. The agenda must be posted at all locations with teleconference locations specifically identified in the agenda. All of those teleconference locations must be open to the public to allow public participation at each location. And there must be a quorum participating from locations within the city of Menlo Park in this case. So as you can imagine, that's kind of annoying. If you're sick at home, for example, and you want to teleconference in, you need to post a notice on your front door and you have to allow people to come in if they want to comment. But during COVID, during COVID, there are sort of abbreviated, I think of them as the teleconferencing light rules. It was under AB 361, which was passed relatively recently. And it allows meetings to be held remotely without observing a lot of those normal teleconferencing requirements if 2 things are met. First, if there's a statewide state of emergency announced, and either one of these 2 things. State or local officials have imposed or recommended social distancing measures, or meeting in person would present imminent risks to the health or safety of attendees. And the city council is actually the body that passes that resolution that would make those findings. And Menlo Park has passed an AB 361 resolution. So your meetings may be held remotely under these provisions until the state of emergency is lifted or until the city council decides to rescind that AB 361 resolution. And unfortunately, I have to leave you folks. It's Grandma's birthday, so I have to head to dinner. But it was wonderful to meet you all, and I'm looking forward to working with you more as we get this redistricting process going. Thank you, everyone.
Thanks, Tamar. So I'll take it from here. So we're going to talk about improper meetings, and we'll start with improper informal meetings. And those are usually talked about in terms of serial meetings. So the Brown Act provides that a majority of the members of a legislative body shall not use a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the body. And that makes sense, right? Because the Brown Act is trying to bring things to light, making sure that these meetings of a legislative body occur in a public forum so that the public can attend and participate. And so the Brown Act provides that you can't have a series of communications to thwart those meeting requirements. So we're going to talk about a couple types of serial meetings, and the first one is a daisy chain. So member A contacts member B, and member B contacts member C, and so on until a quorum has been reached. And then you have a meeting, an improper serial meeting. And it can happen both in a verbal setting. So, member A talks, has a conversation with member B at Starbucks, and then member B sends an email to member C. So it's not restrictive to just, verbal communications or written communications. It can be both or a combination. The next type of improper serial meeting is a hub and spoke. This is where an intermediary contacts at least a quorum of the members to develop a collective concurrence on action to be taken by the legislative body. So sometimes this can happen, a reporter contacts member A and says, member B has told me such and such. And then the reporter will contact member C and say, member A and B have said this, and trying to get all of them to develop a concurrence, or at least to explain what the other members are thinking. And that can violate the Brown Act because that's an improper serial meeting. And again, it can happen through verbal or written communications. And it's often very difficult because serial meetings crop up, when you least expect them. Sometimes you're having a conversation with another, your neighbor, say, for example, and they'll say, oh, I spoke with Commissioner Walter and he said this. And if you get a majority of communications in that way, that could result in a serial meeting. So I always caution officials to, if somebody starts to tell you what another member of the legislative body said or is doing, that you interrupt them and you say, I don't want to hear what, Commissioner Walter said. Obviously politely, you don't want to be rude, but, and you can just tell them that it's, concerns regarding Brown Act. Also the same thing with emails. Sometimes someone will email a number of commissioners and then forward, the response from commissioners or officials to other commissioners or officials. And that can result in a serial meeting. So out of all of the Brown Act issues, I think serial meetings pops up the most on my radar. I have to answer a lot of questions about serial meetings. And I see a question from Commissioner Hill.
I have a question. You just gave an example of somebody emailing to a member with details of a conversation from other members. Receiving that email is something you don't have control over. So how do you recommend?
How do you do that? Yeah. Yeah, it's tricky. Some people, some council members, when they see that, they'll just automatically delete it, or some council members have added a automatic reply to their emails to say, please do not tell me what other council members are saying. And I think those are all good habits. I mean, ultimately, you're not going to be able to eliminate all of the risks, but just being aware, like I said, you don't want it to become a habit, and you want to be able to sort of avoid as much as possible. And I see another hand. Commissioner.
Yeah.
I'm sorry, Saad. What did you say last?
Okay, that is correct.
Okay.
That's correctly pronounced.
I'm sorry, I'm learning all these new names.
Denise, I have a question for you. Is the fact that you read the email or you overhear a conversation will constitute bias by itself, right? It's eventually you read the content. And do you have to share this with someone at the city or the city clerk that you have received or you have overheard, just for someone else to be in the know?
Well, in terms of the Brown Act, no. So if you receive an email that's been forwarded from another commissioner, remember it only is a violation of the Brown Act if you have serial meetings that result in a quorum. So just receiving one forwarded email isn't going to be a violation of the Brown Act per se. But, you could be cautious about, responding to that person or telling them, look, I don't want to know what other commissioners are thinking. But you're not obligated to report that to the city. So, you don't need to do anything beyond that. If you get information on a majority of the body, then you can contact our office and talk about next steps. But usually that there's no reporting element to the Brown Act.
Thank you.
Okay. All right. So improper technology meetings. So as we said, this can happen through verbal, Brown Act violations can happen verbally or written. And a lot of times it's written through social media. So use of email, as we've discussed, social media is a big problem. Unfortunately, you're going to find out very quickly that it can become a serial meeting haven of sorts. And you just need to be aware of that when you're on social media. AB 992 was signed into law in 2020, and that provided that that the meeting definition can exclude meetings, a majority of the legislative body, from engaging in communications with the public on internet-based social media platforms, provided the member does not directly respond to another member. So before 2020, the Brown Act didn't have any provisions about internet social media. And so there were always questions about, well, if a majority of the council is following something on Facebook and they all like something, they hit that like button, is that a meeting under the Brown Act? And that was a question that many lawyers debated. Well, in 2020, AB 992 was signed into law, and that provides that it's not a Brown Act meeting if a majority of council members or officials are on a social media, an internet-based social media platform, which is a defined term, then they can be that on that platform. And they can communicate with constituents, but they cannot communicate directly with each other. So the minute one official starts speaking with another official on that social media platform, that's a violation of the Brown Act. But they can respond to constituents or members of the public on the social media platform to answer factual questions or provide information. Okay. So we have some recommendations for email technology. Avoid sending emails to the whole body for that whole issue of serial meetings. You definitely don't want to email the whole body because that would be a violation of the Brown Act. If you have something that you feel is necessary to provide to the body, then I would work with the clerk to get that disseminated. If you have to provide something to the whole commission, if there's just something that you absolutely have to send to the commission, then you would BCC everybody so that there couldn't be a reply all element to the communication. Be careful in emailing anybody about your work on the commission. Do not communicate your position or make a commitment on a pending matter. You always want to approach an issue in an unbiased manner, and we're going to get to that in a little bit in the presentation. And again, do not direct a reply to a majority of the body for that serial meeting concern we discussed earlier. Think carefully before sending any email. Remember that your emails are a public record and they can be produced through a public record request. And the internet has a long memory. So anything that you say on the internet is probably going to come to light through your work on the commission if it's applicable. So just always be cognizant of your position and what you're writing on social media or through email. Okay, emergency meetings. These are infrequent. The legislative body determines that a work stoppage, crippling disaster, or other activity severely impairs public health or safety. There's a dire emergency, then a meeting can be held with less than an hour's notice if necessary. There are some special meeting provisions applying to emergency meetings, and that probably won't come up for this commission. It hasn't really come up for me very often, but it does come up, and it's important that you're aware that it can occur. Brown Act violations. So there are penalties to Brown Act violations. Typically what we'll see for Brown Act violations is a letter from the district attorney pointing out that there was a Brown Act violation or asking for more information about an issue so that they can determine whether a Brown Act violation took place. And in those cases, if there is one there, you might get a request to cure. And so then the body may have to do something over again to cure the violation. So if a meeting was held improperly, they would hold the meeting again and do it properly this time. There can also be civil actions to prevent future violations, and in some extreme cases, criminal charges. Violations can be misdemeanors. So, well, we talked about what the definition of meetings are, and so now we're going to talk about what are not meetings. And individual one-on-one conversations are okay. So if you are engaging in separate conversations or communications outside of a public meeting with another commissioner, that's perfectly acceptable under the Brown Act. If you're having communications with the clerk, that's perfectly acceptable under the Brown Act. However, you cannot communicate to members of a legislative body the comments or positions of any other members or commissioners. So as I said earlier, we talked about serial meetings, and that's how this occurs is, through these communications, they're one-on-one, but then you start to veer into communicating about other commissioners, other members of the body, and that becomes a violation. It could become a violation through serial meetings. And let me back up. I also wanted to say that it works if somebody else is communicating to you about the position of the commissioner. So those one-on-one conversations are acceptable. But again, if somebody starts talking about the position of another commissioner, politely interrupt them and ask them to refrain from sharing that information with you. Okay, one-on-one conversations are okay, non-meetings are okay. And there are a number of non-meetings under the Brown Act that allow for a majority of the body to come together, outside of that public meeting setting. And the first one that we're going to talk about is a conference that is related to the business of the agency, that is open to the public, and provided that a majority of the members do not discuss amongst themselves business of the body. So if you wanted to go to a conference and all of you wanted to go, that'd be perfectly acceptable if it's open to the public and you don't all meet in a corner to conduct business. So another type of non-meeting is a meeting of a standing committee of that body. So if this body were to create a standing committee and you wanted to attend that meeting, you could, provided that you went and you attended only as observers. So you couldn't go and speak at that meeting, but you could go and attend and listen to the meeting. Individual contacts, we already talked about this. They're fine, they're non-meetings. Other types of non-meetings are purely social or ceremonial events, meetings of another legislative body, community meetings that are open to the public and held by a person or entity other than the local agency and publicized in accordance with the Brown Act. And so there are other types of non-meetings that would allow a majority of the commission to attend events or other meetings. When we have a Brown Act meeting, we follow the agenda. That's a very important aspect of the Brown Act. As we mentioned earlier, you have to give notice of the meeting, either 72 hours in advance or 24 hours in advance, depending on the type of meeting. And those meeting obligations come with also a published agenda. And at those meetings, you can only discuss what is on the agenda. And these are the parameters for non-agendized items. Action or discussion on any item not appearing is generally prohibited. So if it's not on the agenda, generally you're going to have the city attorney jumping out saying, no, we can't discuss this. It hasn't been properly agendized. The legislative body, which is you, the commission, is pretty restricted in what you can do for non-agendized items. And the Brown Act provides that you can briefly respond to public statements or questions. You can ask a question for clarification. You can make a brief announcement or a report. You can provide reference to staff or other sources for factual information, or request staff to place the matter on a future agenda and report back to the legislative body at a subsequent meeting. So those are the things that you can do for a non-agendized item, very limited. Closed session. So the Brown Act does have some provisions that allow for meetings to be conducted outside of public view. And these are called closed sessions. They're an exception to the rule that agency meetings must be open and public. However, the Brown Act really restricts what can be discussed in closed session and provides very strict parameters on the topics and the content of what can be discussed during closed session. It's probably not going to come up for this body because none of the topics apply to the decisions that this body will make. But generally, some of the common topics are litigation, existing or potential, real estate negotiations, personnel matters, and labor negotiations. The disclosure of confidential information is prohibited unless the legislative body authorizes the disclosure of the information. So what's said in closed session is strictly confidential. And it means that nobody can express that information outside of the closed session unless the council has, or the body that met in closed session specifically waives that confidentiality. So here's a headline from the news: loss of open meeting lawsuit to cost city more than $100,000 in legal fees. It's just a cautionary tale from the city of Bakersfield. They had to pay more than $100,000 in attorney's fees after a judge ruled that the city council violated open meeting laws when it had 3 closed sessions. And this sounds like a debacle. The advocacy group somehow obtained slides that were displayed during the meetings and found out what was discussed in closed session and that it was an improper topic. So big problems for Bakersfield, but that's why it's important to stick with the Brown Act. Okay, so who can attend closed session? According to the California Attorney General, no semi-closed sessions. So only people that are absolutely necessary to be in the closed session. Essential support staff, legal counsel, consultants, and other people with an official role in the item. All right, so now we're going to move from the Brown Act and talk about public records. And public records are, sorry, I'm switching my notes now. So public records are accessed by the public through the California Public Records Act, which is found at Government Code Section 6250 et seq, and was signed into law in 1968. If some of you are familiar with the Federal Freedom of Information Act, FOIA, the California Public Records Act is somewhat based on FOIA. But FOIA doesn't really apply to the city. It only applies to federal agencies. So we only deal with the California Public Records Act when we are looking at responding to public record requests. The California Public Records Act is actually a constitutional right, and it provides the public with that constitutional right of access to information concerning the conduct of the public's business. Public record means any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by the state or local agency, regardless of physical form or characteristics. So this means any writing can be in print or electronic form. It could be photos, calendars, texts, emails, social media. We have a lot of records that are created through, city Facebook pages or Instagram pages. And those are all public records that can be requested by any member of the public. It doesn't matter where they live. It doesn't matter why they want it. They can request it and they're entitled to receive it. I will say, though, that the Public Records Act does not require an agency to create a record. So if the agency doesn't have the record, it's not obligated to create a record. So public records exceptions, there are a number of exceptions under the Public Records Act that would preclude the agency from providing the record. Some of the major exceptions include preliminary drafts not ordinarily retained by the agency, pending litigation, personnel records, attorney-client privilege records, and then there's this catch-all found at Government Code 6255, and it requires the jurisdiction to weigh the interest. Is the public interest in producing the record outweighed by the public interest in exempting the record, withholding the record? And that's called the public interest exemption or the balancing test. And so the Public Records Act, for a while, it was unclear whether emails or texts on personal devices were subject to the Public Records Act, because it was not clear whether those were records that were under the custody, control, or ownership of the agency. And then came the City of San Jose versus Superior Court. That case that was decided by the Supreme Court determined that they are subject to Public Records Act requests. So if you send out emails through your personal email account, or if you send texts on your personal phone relating to the city's business, then those could be subject to a Public Records Act request. In San Jose, the case arose over a public records request where the requesters sought 32 categories of documents. And I was actually working for the city of San Jose when this all came to started occurring. So I have a personal connection to this case, but they sought over 32 categories of documents relating to redevelopment efforts in downtown San Jose. One of the requests sought emails from and text messages sent or received on private electronic devices from officials. The Supreme Court ultimately found that emails and texts are subject to the Public Records Act. They are a public record. And the court found that communications that had related in substantive way to the conduct of the people's business should be produced. So that created this new test. Does it relate in some substantive way to the conduct of the people's business, or is it primarily personal? And this may require us to go through those emails to make that determination. And we look at content, context, purpose, audience. Was the individual acting within the scope of their employment or office? Lots of different analysis that we will do to determine whether or not the document needs to be produced. But it's just important for you to recognize that these, emails, texts that you do on your personal devices or accounts could be subject to a public records request, and keep that in mind when you're making those communications. So now we're going to move on to the second portion of the agenda. And this is personal financial interests and fair processes. So we're going to talk about conflict rules in this section, and conflicts of interest generally describe a situation in which the concerns or aims of two parties are incompatible. And this sort of comes from, this idea comes from biblical verse that says, you know, a person cannot serve two masters, and I'm paraphrasing. But that's how the conflict of interest rules sort of are framed. You as a public servant now can only serve the public. You cannot serve your own financial interests or personal interests. And so with this idea comes the public's interest in knowing and expecting that its officials act in the public's interest without regard to their financial or personal interests. So the official owes a duty of paramount loyalty to the public. Personal or private financial interests should not be allowed to enter into the decision-making process. Remember, conflicts of interest are not limited to financial conflicts. There are a number of ways that conflicts can come up. That can be a statutory conflict of interest, and we'll talk about that under the Political Reform Act. There can be a common law conflict of interest, a bias because you have a personal stake in a matter. And there can also be conflicts of interest that arise from contractual relationships. So there's a variety of ways this can come up. And again, we don't expect you to become experts after this presentation, but we're hoping to give you enough information that you can spot these early on. If it just doesn't feel right, or if it just sounds a little bit weird or not on the up and up, then that's a flag for you to come talk to us, essentially. Okay, so as I mentioned, there are different types of conflicts. We have the Political Reform Act, and that's Government Code Section 87100. And then from the Political Reform Act, the Fair Political Practices Commission has adopted regulations, and those also govern conflicts of interest. And then there are contractual conflicts under Section 1090. So again, just we're hoping that you're going to learn enough tonight to spot the issues and to be able to contact us if you have questions. It does take a lot of work to analyze a conflict of interest question, especially under the Political Reform Act, because the regulations are fairly complex. And as Tamara mentioned at the beginning, the FPPC advice letter is really the only defense if you if you're trying to ensure that you have an appropriate defense against a conflict of interest. The FPPC advice letter is the only thing that would provide you that defense. And that takes time to obtain. The FPPC receives over 20,000 requests in a year for advice, both informal and formal. And so they're a busy group. And the formal advice letters take approximately 21 working days to obtain. So if we want to send a request to the FPPC, we have to plan ahead. I often get calls the day of the meeting, and that's fine. I'm happy to do that, asking about questions or conflict questions. Oh, I realized, on the agenda, there's this contract. Do I have a conflict of interest? And the problem is that usually I don't have enough time to analyze whether you do or do not and provide you sound legal advice. So what I'll say usually is, in an abundance of caution, you should recuse yourself. And then we can conduct the analysis after the meeting. All right, so disclosure of financial interests. All of you had to provide Clerk Karen with a Form 700. So hopefully you've done a little homework and understand what the Form 700 is all about. But generally it's a tool that comes from the Political Reform Act to allow the public to understand where your financial interests come from. So it alerts officials of those interests and how they might be affected by a decision, and informs the public about those potential conflicts. They are a public document, and you do need to file them upon 1 month after taking office, and then after you terminate your office, and then every year annually thereafter. And in terms of the Form 700, who, what, when, and where is the disclosure. So who, all designated officials, and those are also officials under the Conflict of Interest Code that the city has adopted. What are you disclosing? You're disclosing interests in real property, investments, business positions, sources of income. When, upon assuming office annually, and upon leaving office. And you must file with the clerk. Some filers file directly with the FPPC, but you're going to be filing with the clerk. So can I participate? So now we're going to get into the Political Reform Act and some of the conflicts of interest that could preclude you from participating in a decision. And the general rule for disqualification is a public official may not make or participate in the making or influence a governmental decision that will have a reasonably foreseeable material financial effect and material financial effect on the officials or his or her immediate family's financial interest that is distinguishable from the effect on the public generally. So now you understand why these conflict questions can be very difficult to analyze. I mean, if this is the general rule, you can only imagine what the actual regulations say. It's a jumble. So, but you know, we're going to break this down a little bit. But one thing I want to talk about is that it does include immediate family. So spouse, dependent children. You've got to be thinking about them as well, because they can have interests that create a conflict of interest for you that would disqualify you from participating in a decision. So the FPPC has provided, a 4-step test to identify the financial conflict. And first you ask, is it reasonably foreseeable that the decision will have a financial effect on the official's economic interests? Will the effect be material? Is the effect indistinguishable from the effect on the public generally? Is the official making, participating, or making, or attempting to influence the decision? And at each step, if the answer is no, then you stop the analysis. If it's yes, then you continue to the next step. And I see a question from Commissioner Vice Chair Gilmer.
Yeah, I'm just curious, given the limited nature of the IRC and what we're going to be doing, are we likely to have any instances of financial conflict?
Well, you could, it will be limited, much more limited than say the Planning Commission, because like, for example, the Planning Commission sees a lot of financial interest in their real property. And that won't come into play for the IRC because you're not dealing with real property questions. But it could come up if say a consultant contract comes before you, or if a consultant is going to appear before the body. Those are really ways that it could come up.
Okay. Thank you.
Yes. Okay. So business entity is a potential economic interest. Any business entity, which is a defined term, in which the public official has a direct or indirect investment worth at least $2,000, or in which the public official is a director, officer, partner, trustee, employee, or holds a position of management. So, as I mentioned, we could have, the IRC could use a consultant. And if that consultant is somebody in which a commissioner has a business interest in, that could be a conflict of interest. Real property, as I mentioned, this is probably not going to come up with the IRC, but if a decision that you are making is located within 500 feet or up to 1,000 feet of real property that you own, that could be a conflict of interest, an economic interest. That could create a conflict of interest. Indirect investment is an investment or interest owned by the spouse or dependent child of a public official, by an agent on behalf of the public official, or by a business entity or trust in which the official's agent, spouse, dependent children own directly, indirectly, or beneficially at least 10% public interest, sorry, it's getting late. This doesn't come up very often. It's usually the real property or the business interest or the source of income. So if your employer, for whatever reason, has a contract that's before the IRC, then that could be a financial interest that creates a conflict of interest. Just any source of income that amounts to at least $500 provided or promised to. It doesn't even have to be income that you've received. It's promised to and received by the public official within 12 months before the decision is made. A gift, somebody provides you a gift and then they appear before the IRC asking for a contract or some other benefit, that could create a conflict of interest. And the FPPC does issue decisions and enforces the Political Reform Act. And in this decision, a council member violated conflict of interest laws by voting to obtain $491,000 and change in a grant to extend water and sewer line to an area of the city where he owned real property and operated an inn and restaurant. So he had a lot of financial interests in that decision, but he participated anyway. Cautionary tales. Another cautionary tale. This is one I like because it could come up very easily. I mean, I could see this happening to me, frankly. This was a member of the San Diego County Board of Supervisors, and his spouse purchased shares of SeaWorld, and he was unaware that she had made this purchase. And then SeaWorld had an application before the Coastal Commission, and a member sought to add a condition banning captive breeding, and Gregory was the lone dissenting voice. And so he participated in that decision, even though he had a financial conflict of interest. His share of his wife's stocks would be half, but he still has a share in that value. So there are exceptions to potential economic interests. There are first off, the public generally, and that comes up very frequently. And the second one is the legally required participation. So the public generally is a regulation that provides that you can take part in the decision if the decision applies equally to other areas of the jurisdiction. Usually it's must be a significant segment of the public, and that significant segment means at least 25% of the businesses or nonprofit entities, real property or commercial property, or individuals within the official's jurisdiction. So if the decision is going to affect, say, 25% of all individuals within your jurisdiction, then the public generally exception would apply. The same would be true for businesses. If the decision is going to affect 25% of the businesses in the jurisdiction, then the public generally exception would apply. If it doesn't, you can still participate if you're legally required to participate. So if you have a decision where 4 commissioners are disqualified from participating, but you have to have a decision. The commission has to make a decision. Then the legally required participation exception would apply to bring those commissioners back in so that we could have 4 back in to participate and have a quorum. So this is a little bit more about the public generally exception we just discussed, the legally required. It does not apply if a quorum could later be met. So if there is a way to make the decision and it's just that somebody isn't there or a couple of members are absent, then the legally required exception would not apply. It only applies to bring people back in if you just can't make a quorum because of the conflict. And it also does not apply to break a tie vote. So what happens if you're disqualified? You will identify the applicable interest. Now that we're all doing this on Zoom, you would still identify the applicable interest on Zoom. And then on Zoom, you would turn off your camera and your mic and wait until the decision has been made. And then you can come back on to the meeting. If we were in person, you would still identify the applicable interest. You would step down from the dais and leave the room, except if it's on consent, and refrain from any discussion or participation. You would usually go to some area outside of the main room where the meeting is being conducted so that you can't be seen or heard from. You could participate on certain issues, personal economic interests, as a member of the public. And if there is a personal interest that you wish to speak on, even though you're disqualified, you could participate just as any other member of the public, and you would, it's recommended that you identify yourself as speaking as a member of the public rather than from your position as a commissioner. So this is another cautionary tale. Robert S., member of City Council, attempted to use his official position to influence a governmental decision in which he had a financial interest, speaking before the Planning Commission regarding approval of an application for a subdivision of land owned by a client. So he was speaking, trying, as a council member, I'm sure, trying to wield his influence to convince the Planning Commission to do something favorable to his client. And that's a definite no-no under the Political Reform Act. So we talked about statutory conflicts of interest under the Political Reform Act. There's also common law conflicts of interest that are derived from case law. And that this body of law holds that personal interests or biases, either positive or negative, about the facts or parties may cast doubt on your ability to make a fair decision. And you, as an official, must exercise power with the appearance of disinterested skill, zeal, and diligence. So this common law conflict of interest comes up a lot in quasi-adjudicatory hearings. This body is not going to be quasi-adjudicatory, but Planning Commission is a quasi-adjudicatory body. So they are acting in some capacity as a judge, making decisions. And so constitutional limitations on due process require that they hear a matter in a fair and unbiased manner. And so many cases, many courts have developed this idea of a common law conflict of interest. And so we look for that when we're talking about conflicts of interest. We'll analyze those as well and identify them for the officials so that they're aware, because these also bring to mind that whole perception, right? There's statutory conflicts, but then there's these common law conflicts which provide the public's perception of whether an official is acting in their best interests. And if you're biased, if you can't make a decision in a fair manner, then the public perceives you as someone who is not acting on their behalf, and that's important. Another type of interest that we're going to talk about is contractual conflicts of interest under Government Code Section 1090. Section 1090 prohibits officials and employees from having financial interests in contracts made by them in their official capacities or any board of which they are members. And although the statute says contract, Section 1090 has been applied broadly to grants or payments to nonprofits, development agreements, payments of travel expenses to a board member's spouse. It can be extended in a lot of ways. And I think the key takeaway for this section is that if it's some sort of written document, written obligation for any amount, it can be a penny, it can be for nothing, then that you have a financial interest in, that should be a red flag for you. You should talk to us so that we can analyze whether or not it's prohibited under section 1090. The general rule is that public officials are absolutely prohibited from having a financial interest in that contract made by them or the body. It prohibits self-dealing. Like I said, 1 penny is enough. The individual's conflict extends to the entire commission. So it's not just you, and it may not be enough that you recuse yourself. It may extend to the whole body and prohibit the whole body from acting on that contract. Consequences of a 1090 violation are severe. It can void the contract. It can also require the official to return any money. There can be fines, imprisonment. There are, of course, exceptions to every rule. There's an exception. And for 1090, there are remote interests. So, there are a number of areas where the interest that you have in the contract is so remote that the legislature has decided that that's not a conflict of interest, but it's a remote interest. And non-interest, non-compensated officer of a nonprofit, for example, is a non-interest. But with some of these remote interests and non-interests, you may still have to abstain from voting. So if you have an interest in a contract, like I said, come to us early so that we can decide whether there's any exceptions that apply and whether it's enough for you to recuse yourself. So just touching on other fairness and processes. So we touched on due process a little bit earlier for quasi-adjudicatory hearings. There's also public bidding requirements. So those have a number of processes in place that provide fair and open, transparent steps so that the public can see how decisions are made. There are non-discrimination requirements for the city on certain issues. And of course, embezzlement is prohibited under Penal Code Section 424. And those are other fairness and process laws. So just going to touch on this quickly. Due process considerations, quasi-judicial or administrative hearings subject to fair process requirements. If a vested property or liberty interest is implicated, the hearings are subject to due process under the 14th Amendment of the US Constitution. And that's why, a lot of the Planning Commission hearings have so many notice provisions, notice requirements. Those apply to those types of hearings. 14th Amendment requires proper notice, right to present case, fair, unbiased decision makers. These due process requirements do not apply to purely legislative actions, which is primarily what the IRC will be doing, is adopting a resolution to establish district boundaries, which would be a legislative action. Incompatible offices. I'm just going to touch on this. This is Government Code Section 1099. Codifies the common law prohibition of incompatible offices. So sometimes officials can hold 2 offices that are incompatible, and that would be statutorily prohibited. If one office exercises a supervisory, auditing, or removal power over the other offices, there is a significant clash of duties or loyalties between the offices. There are public policy considerations that make it improper. And the consequence of having or holding an incompatible office is that the person is deemed to have forfeited the first office upon succeeding to the second office. It's inapplicable where specifically authorized by statute. Some positions are allowed to coexist, I guess is a good word, to a position of employment, including civil service position, to a governmental body that has only advisory powers, and where a member of the member body holds an office that may audit, overrule, remove members of, dismiss employees of, or exercise supervisory powers over another office when the body has any of these powers over the other office or over a multi-member body that includes the other office. Boy, that was a mouthful. So just know that that this is out there, this body of law is out there. If you're holding two offices as a commissioner and if you're on some other body, just reach out to us and we can talk to you about that other body to determine whether they're incompatible offices. Okay, the final topic for this evening is the legal limitations on personal advantages or perks. And perks, by the way, are not good where that's prohibited. If it's not clear, let me make it clear. So expense reimbursement. From time to time, you might be reimbursed for expenses, actually, or necessary expenses as a commissioner. Somebody picks up bagels before the meeting and you're going to ask for reimbursement from Clerk Karen. That's fine. You just want to make sure that you are reporting the reimbursement honestly and realize that there could be a penalty associated with improper reporting. Remember your expense report forms are public records. Much of any writing that you do for this commission is a public record, but the expense reports could be requested through a public records request. Gifts. Gifts are anything of value you receive for which you do not provide monetary or other consideration of equal or greater value. It could include discounts, rebates. I've had situations where somebody was gifted a lottery ticket and won. I've had situations where somebody was gifted a raffle ticket and won. There are lots of ways that gifts can come up, and usually they're not always self-evident. So it's, again, you want to be aware of these regulations, these requirements, so that you can spot the issues. And just know that if anybody gives you something of value for which you haven't provided any consideration or done anything to earn it, then that might be a red flag for you. Report, it's $50. You have to report any gift over $50 or more from one source in a year, and that's aggregate. So if somebody takes you to lunch every Friday and pays for your lunch, and that aggregates to more than $50 a year, then you would need to report that. The maximum gift limit is $520 per year from the same source. When you receive a gift over $50, you can always ask yourself, what am I going to do with this gift? Decide if you want to report it on your Form 700. If so, you need to report it within 30 days of receipt. If not, if you decide you don't want to keep it or you want to do something else, you can reimburse the donor for the fair market value of the gift. You can return the gift unused, or you can donate the gift to charity, but you cannot claim a deduction. If the gift exceeds $520, then you have a duty to reject it, or you could buy down the value of the gift. Disclosure of gifts, you must report the gifts on your Form 700 if the total value of all gifts from that source during the calendar year is at least $50. Gifts are reportable regardless of the location of the donor. If the amount is unknown, you must make a good faith estimate of the fair market value of the gift. That's often very difficult to ascertain. And that's sometimes where we've contacted the FPPC and asked for informal advice because it can be very difficult to ascertain what something is worth, especially on gifts that are unique. And these are some headlines of officials who accepted gifts. It's, these I think are fairly extreme. Like I said, they come up in a lot of different ways, sometimes seemingly innocuous, but just again, be aware of anybody giving you anything. Are meals gifts? Yes, meals are gifts, unless they're provided at an individual's home. If you have an existing relationship with somebody and they're, cooking you a meal, that's not a gift. If they're provided as part of a reciprocal exchange, everybody's doing a buffet, that's not a gift. If it's paid for by a governmental agency, then it's not a gift. This is an FPPC enforcement decision where the mayor of Palmdale failed to timely disclose gifts of 2 meals totaling $253 on his statement of economic interests. All gifts were from EJ De La Rosa and Company, and he did get a penalty for that. It's hard to remember, to report those gifts in a timely fashion. So just keep that on your radar as well. There are, again, many exceptions to the gift limitations. Gifts from family members, you do not have to report. Food gifts for the office, those do not need to be reported. Trophies, plaques, less than $250, those also do not need to be reported. There's lots of exceptions. There's donation of gift to a nonprofit. There's inheritance is also an exception. Campaign contributions, ceremonial roll tickets, bereavement offerings, acts of neighborliness. Those are all exceptions to the gift, the rule regarding gifts. Wedding gifts, I don't know, I hope a commissioner is not going to get married during their term in office because those are very complicated. Wedding gifts are not subject to the $520 limit. However, wedding gifts are reportable, but only half of the value is yours. So you would only report half of the value of the wedding gift. I can only imagine the nightmare of going through all the wedding gifts to figure out what half of the value of each one was. I mean, it would cause me to not want to get married. All right, so this probably, we could just skip this one. This is obvious. You can't accept gratuities or rewards. But this one is less obvious. Prohibited travel discounts. This is actually in the Constitution. A transportation company may not grant free passes or discounts to anyone holding office in this state. And for some reason, that's just never been amended, but that is the rule. So don't accept any free passes from BART or Amtrak or anyone. FPPC Reg 18950 also prohibits acceptance by public officials. Honoraria. This is anything that you could receive in exchange for a speech or article or attendance at a conference. Those are prohibited. You could return or donate the honoraria within 30 days of receipt to avoid the prohibition. Misuse of public resources, no use of public funds or resources for personal or non-public purposes, including campaigns. So, if you could go to City Hall and do work there, don't use the phones for personal business. Don't use their copiers for personal business. There are stiff penalties for that. Rule against advocacy when conducting official activities. This just provides that in your official capacity, you may present information in an even-handed manner. You cannot conduct advocacy activities in your official capacity. So, public agencies are supposed to not be advocates for certain issues. And so there is this rule against advocating for activities while you are acting as an official commissioner. You are perfectly able to do that on your own time. If you have a ballot measure that you really are pushing and supporting, or a candidate that you are pushing and supporting, that's perfectly acceptable on your own time, but don't do it, from the dais. And we just talked about that. Solicitations of political support. Gifts of public funds. Local agencies are prohibited from making a gift of public money or anything of value. Expenditures for public purposes are not considered gifts, even if a private party incidentally benefits. So the public purpose must be within the scope of the agency's purpose. And generally, there's that what is a public purpose is interpreted very broadly. So a local jurisdiction gets to decide what is an expenditure for public purpose, and it's usually, like I said, very broad. Mass mailing prohibition. So this is a topic that's usually covered in AB 1234 training, because it is a very important statute relating to the public agency's business. A mailing is generally prohibited if each of the following criteria is met. Delivery, so it has to be a mailing that is delivered, a tangible item, newsletter or brochure, and it cannot feature an elected officer. The item is sent either features an elected officer affiliated with the agency, and no public money can be used for the mailing. So any of the costs of distribution are paid with public monies in excess of $50 and mailed to more than 200 substantially similar items are sent in a calendar month. So this probably won't come up for you because you're not going to be conducting the mass mailing, but like I said, it is taught in AB 1234 because it is such an important part of the local jurisdiction's business. This mass mailing prohibition comes up in a lot of ways. And here's Rockland. They got fined $2,000 for this newsletter. Again, something that looks very innocuous, right? I mean, I think we'd get this in the mail and probably most of us wouldn't blink an eye at it, but it is prohibited under the mass mailing rules because it features the council members, one more predominantly than the others. And that is, it was mailed to more than 200 people. It was mailed out and they spent presumably more than $50 on the mailing. And so it was prohibited mass mailer. The state considers such activities a prohibited form of campaigning with taxpayer funds that gives the incumbents an unfair advantage. And you can kind of see that in the pictures, right? Because somebody other than an incumbent doesn't have that advantage of being able to send out these mass mailers. So restrictions on loans. So as an official, you can't have a perk of getting a better loan from somebody or from a bank. You cannot receive loans from anyone within the official's agency or with whom the agency contracts. Greater than $500, except in writing and with clear terms. So the exceptions are loans received from the official's campaign committee, normal bank and credit indebtedness, and loans from family members. So those are all allowed, but there are some restrictions on loans as an official. Here's another FPPC enforcement decision. There was inspection services manager for the city, and they violated the conflict of interest laws when they approved and signed a series of contracts with a contractor, her former brother-in-law, from whom she had received a loan in the amount of $50,000. So that's definitely a no-no. All right, so final questions to ask. What would inspire public confidence? When we go through these trainings, we ask you to think about it, big picture. What's going to inspire public confidence in the people that you serve? What's going to be the most transparent way to conduct business? And what decisions best serve the interests of the community as a whole? And then there's the sign for the high road or the low road. Of course, you want to take the high road. Public perception is very important. As we discussed during the presentation, there's actual violations of the law, but there's also public perception, and that's important to consider. Even if you are confident about the right thing to do, don't forget about public perception. So maybe your actions comply with the law, but because of public perception, you decide you should recuse yourself or you should do something different than what is actually what you had originally planned to do. The public needs to believe that the right thing has been done. Resources. So there are lots of resources available to officials. As I said, the FPPC offers informal and formal advice. They have a hotline, and you can ask your question via online resources. The Attorney General of California is also a resource. The League of California Cities, we need to update that. It's now Cal Cities. And the Institute for Local Government, that's one of my favorites. They are also a valuable resource. All right, so you made it. It's a long presentation. I know a lot of information to take in, but now's the time when you can ask any questions that you'd like. Yes, Commissioner Saad.
Yes, Assistant City Attorney. I have a question for you. I noticed that all what was mentioned were tangibles in terms of loans or donations or gifts. But how about the intangibles, which are the favors normally? So someone does someone a favor, but then you cannot put a dollar amount on it, and then that kind of constitutes bias.
It depends on what the favor is. I've had that come up. I've had that come up before was two professionals, and they both sort of had an agreement, an informal agreement to refer clients to each other. And one of the professionals was a planning commissioner, and the other professional was going to appear before him in the at the planning commission meeting on a application. And in my research, I couldn't find anything specific under the Political Reform Act that prohibited him from participating in the decision, because it wasn't a financial interest. But ultimately, he decided to recuse himself from the matter because of that public perception. He didn't want, that he wanted to instill public confidence in his decision-making ability. So he decided, you know what, I'm just going to recuse myself from the decision and not even be involved, because, while I don't have a financial interest, it's the public perception that I'm concerned about. I also think that for him, it could have been, there could have been a situation where it was a common law conflict of interest. We talked about that a little bit. If he couldn't make a decision in an unbiased manner, he told me that he would be fine making a decision for or against the application, and that he would look at all of the facts of the application in an even-handed manner. But it could come up in another situation where the common law conflict could present a problem. But that's a great question. And if you think of, if an issue comes up where you think, this person's going to appear before the IRC and I've given them lots of favors, contact us, because, there could be, depending on the favor, there could be an implication of a financial interest.
Yeah, I had an interesting question for you as a follow-up. I know Commissioner Gilmer is raised his hand, but regarding the loans, I remember that almost a decade ago, City of Menlo Park provided or guaranteed a low interest rate loan for the city manager to join. Is this something, it's an exception, or how does that happen?
Yes, that's the agency providing the loan is acceptable and often done, like you said, for city managers. There's the public interest is that they want to bring, they want to recruit somebody to come work for the city, and because property values are high, they can't properly recruit without offering that incentive. So that type of loan is acceptable. But that's great issue spotting. I'm glad you paid attention.
Thank you. Of course. Thank you so much.
Okay, Commissioner Gilmer, I see your hand.
Yeah, I just have a couple of, well, hopefully quick questions. Going back a bit in your presentation, to the open records and the discussion of emails sent from private accounts could be impacted. Is that something where we should get an email address that's related to the city provided so that all communications can be kept central and in one controlled location so that we don't have to open up our personal email?
So that's a great question. I will ask Commissioner Clerk Heron to answer whether or not the commission will receive city emails.
Thank you, Assistant City Attorney. So the city does not provide personal email addresses for all of our advisory body members, planning commissioners, or our IRC. What I have seen people do is they create like a generic Gmail account or Yahoo account, stating like their last name and the commission they're on or something like that. And then they only use that for city communications.
Yeah,
Great.
and I would recommend that as well. I think keeping those emails, those commission emails separate is, I think, going to be easier for you in the long run if you get a public records request, and they make you more efficient as a commissioner.
Great. The second question, and it was related to gifts. I know the gift giving season is approaching, and there are times when we get gifts as a family from people who will give us gifts in excess of $50 and give my children particularly gifts in excess of $50 where we may not reciprocate. And it may not be from a family member, it may be from a close friend. Are those gifts, do they need to be reported?
So if it is somebody unusual that has never given you a gift before and you can't figure out their motive, then contact us and we can discuss whether or not it needs to be reported. If it's over $50, then it may likely need to be reported. But
I'm more interested in like people that we've exchanged gifts with before, family, friends.
yeah, if it's people that you normally exchange gifts with, family, friends, neighbors, that's fine. Generally okay. But
Great.
it's
Thank you.
the uncommon gift giver that should send up a red flag, that you should reach out to us to figure out if that should be reported or needs to be, something needs to happen with that gift.
Okay, thank you.
Commissioner Saad.
Ma'am, is this presentation going to be available for us to review later on?
Yes, I believe it will. Clerk Karen, is this going to be, is the PowerPoint going to be posted online? How is that going to work for the commission?
Yeah, so following this meeting, I will forward the presentation to all of our commission members. It will also be attached to the meeting minutes of this meeting, which will be brought before the commission for approval at your next meeting.
Okay, any other questions? We have a bit of time, so if anybody wants to ask, now is the time.
If you'd like, we can open it up to public comment, and
Oh, that'd be great.
if the commissioners want to just take a couple minutes to absorb it all. So at this time, if any member of the public wishes to speak on item E1 related to the Assembly Bill 1234 presentation, please engage that hand feature in the bottom of your screen. If you're calling in from a landline or a cell phone, you may press *9 now. So this will be the final call for public comment on item E1. Seeing none, I will return it to the commission. Thank you.
So maybe I could ask the commission to give me a little bit of background on how many of you have experience with the Brown Act or the Public Records Act.
I can start.
Okay.
I have a lot of experience with both. And in my day job, I'm also an assistant city attorney for the city of Santa Clara.
All right, that's fantastic. So you know it thoroughly. You probably could have taught this with me.
not as well as you.
I doubt it. I doubt that, but thank you. Okay, and what do you do for, can you share what
Sure.
department you work in?
Sure. I advise principally the utilities department, so the electric utility, water, sewer, public works as well, and then hodgepodge of other departments. But I've done the full slate: planning, community development, public safety, city manager, city clerk.
Fantastic, fantastic. All right, anybody else?
I have some experience with it, having served on previous committees and just, following the city council and general issues and news. That's about it.
And who was just speaking? I'm sorry. I couldn't-
Gilmer.
Oh, okay, Vice Chair Gilmer, okay. Yeah, so that's fantastic. So the chair and the vice chair have significant experience with the Brown Act and will be able to lead these meetings very efficiently and with expertise. So that's great. And, and as I mentioned at the beginning, it's the Brown Act is critical and conducted in this meeting. Oh, I see some hands, so fantastic. Commissioner Ballas?
Yes, hi,
Hi,
Ballas.
Dallas.
Ballas, I think there might have been, this question might have been asked in a similar way, but given that this is the nature of the work we're doing, which is the redistricting, other than a financial or on the surface, perhaps conflicted relationship with a consultant, I don't even know if we're going to use consultants, but if we did, other than something like that, can you just, with the understanding that I'm not asking you to be exhaustive, but is there likely to anything else come up with this sort of narrow focused commission?
Yeah, I mean, I do think that's probably, if it's going to come up, that's the area it's going to come up in. We did talk, Tamara and I did talk about this at length before the presentation, trying to figure out, like, can we take out slides? Can we, move things around?
Oh, that's okay. I just, that's why I said I'm asking for a formal, no, it's definitely just this, but just in general, it sounds like this was a complete, and I'm very helpful. I have not been exposed to this before, so I found it reasonably interesting, especially as background stuff. But I'm just thinking in terms of anything that would benefit one of the people on the committee, on the commission, is versus benefiting the community as a whole, because it's a redistricting. One could make the argument that any given decision of a district that benefited you, let's say I made a decision that in some fashion benefited the district in which I live. How does that sort of thing, I mean, how do you even get people to participate if there's a conflict of interest, if my district benefits and some other district, and some of the district doesn't?
Yeah, I think I understand what you're asking, and we did discuss this a bit. I think those decisions relating to the boundaries,
right,
are not arguably benefiting just one district. They're benefiting all of the districts in the city, and that's what would bring your activities under the public generally exception, because that would affect all residents of the city, all properties in the city, right?
Okay. Right.
But in terms of the conflict of interest, the way I think it could come up is in the, like we discussed, if you have a financial interest in a business or a source of income that comes before the IRC, for a consultant contract or some other contract,
right, that
could create a conflict of interest. And I just don't see any other way that it could come up. But these conflict of interest questions come up in the most weird ways sometimes. So I don't want to exclude things. And that's why ultimately we chose to leave in all the slides.
Exactly.
Because we want you to understand how these issues come up, even if they don't come up during your tenure.
Okay, so generally just if something kind of feels funny to you, ask a question.
You trust your gut.
All right.
All right, Vice Chair Gilmer.
Yeah, I had one question. It wasn't really covered, but I know that it's not uncommon to have a Brown Act buddy somebody that you've identified that you can exclusively discuss things with between, I know that on the our city council, which is a 5-member city council, there's 2 Brown Act buddies because they don't constitute quorum. So my first question is, could you talk a little bit about that? And the second follow-up is it 2 people on a 7-person commission, or is it 3 people on a 7-person commission?
Yeah, so, you know, as Vice Chair Gilmer said, some bodies have, some officials have a buddy that they go to just sort of do that one-on-one, which, as we discussed, is perfectly acceptable under the Brown Act, the one-on-one. So, and that is generally acceptable. What you have to be careful of is, even if you have that buddy that you're doing the one-on-one with, that they also agree that they're doing the one-on-one with, and not anybody else. So you both have to sort of make clear that you're going to be each other's buddy. And for the IRC, so the quorum would be, a majority would be 4 of the body. And so if you're having a conversation with 3 exclusively, I think you'd be okay. But you'd have to make sure that those 3 are not talking to anybody else. And it, you know, it can get very difficult when there are multiple, you know, so you'd want to make sure that you're talking about, well, I guess the IRC, it's really going to be one issue, right? With the redistricting. But for other bodies, you have to make sure that they understand what topics you're all being buddies on. Does that make sense, Vice Chair?
Yeah, that's what I was, that's what I wanted to know. Thank you.
Mm-hmm. Any other questions? These are all great questions. I love it. It's fantastic. You guys are all engaged. And I knew that would be the case from looking at your applications and resumes. So that's great. Commissioner, I'm sorry, McCart.
Good evening. I'm one of the 2 alternates, and I just wanted to ask if you could speak a little bit about any special considerations for the 2 of us. We're held by the same rules, but we don't count towards quorums. I don't know if there's anything else that you can speak about.
Yeah, so I mean, that's correct. You are alternates. You're not going to be voting members, so you don't count towards the quorum. But you do want to be cognizant of that perception issue. You also you are you're on the commission, so you want to be cognizant of conflicts as well. If you have questions about what you should or should not be doing, then please feel free to reach out to us, because you're going to be participating in the meetings, and so you need to be cognizant of all of these ethical rules and obligations as well. Any other questions? All right, I don't see any other questions. So I will turn it back over to Clerk Karen.
Thank you, Assistant City Attorney, and thank you for your time this evening. And for members of our commission, if you ever do have questions, I can get you in contact with Denise if I'm not able to assist. If something comes up following this meeting that you have questions on, please always feel free to email or call me. I will say that this does conclude our first official meeting of the IRC, so congratulations. I will be following up again via email, probably tomorrow afternoon, with again the PowerPoint from Assistant City Attorney's presentation and just some other housekeeping issues. So thank you very much, and we will officially adjourn the meeting.
We have a Clerk Karen, we have a
Yes.
question from.
Yes.
Just one real quick on the Gmail email addresses. can you send out in your follow-up email to us just a suggested
Sure.
standard, like first initial, last name, IRC or
Exactly. And that
IRC,
would probably be.
whatever. And that way
Exactly.
we'll all have the similar looking thing and can find each other.
That's actually a wonderful idea. Thank you. Yes.
All right.
I'll send out a couple of options for that.
Good suggestion.
Definitely. Okay, so now we will officially adjourn and I will see you all soon.
Thanks, everybody. Nice meeting you.
Good night, everybody.
Thanks to the city staff for being on so late.
Yeah, you guys are great.
We appreciate
Thank
you
you
guys.
and congratulations to all.
Yep, welcome to the team.